Hello everybody, we're doing another video. This is an unusual one. As always, these videos are given under the auspices of entertainment, I guess, information and research, information that you need. You be you, I'm not telling you what to do, I'm telling you my experience, and hopefully it meets with yours in whatever state you're in. Today we're going to, as I usually say, we're going to go sort of Michigan-centric, and there's a good reason for that. The name of the video today is having to do with a company called SoloSuit. I tool around and try to do research for you. I've got pages of stuff I want to say, and sometimes I go a little off the rails on top of that. But I bumped into this SoloSuit a couple of weeks ago, and I've said I'm going to do a video on them. This is it. I watched a video about 15 minutes long from a guy called George Simmons giving people advice, and he was giving them 6 tips how to answer a lawsuit. And I am amazed that this guy hasn't been shut down. The advice he's giving is wrong, especially for Michigan and others that are facing lawsuits from what's called an account-stated statute. We have a complaint usually filed against us in a number of states, and it'll say breach of contract if it's a credit card debt or a collection case. He's giving tips on how to answer a collection case. And it's usually a breach of contract, an account-stated statute, and sometimes they throw in something else like unjust enrichment. But you've got to break it down to give advice. You've got to be in Michigan to give Michigan advice. We got a lot of good people here facing struggles, hundreds of thousands of people that he's giving advice to that I'm going to go over now. And it's not nice what he's doing, and they're making money telling people that they are the place to go. But let's take a look. This is a review of SoloSuit's 6 tips to answer a lawsuit. Now, before I go any further, this may sound unusual, but the difference between federal and state is certain rules apply for you to be in federal court. Generally, you're in state court. With collection lawsuits, it's all state court. You go to your local district court and you're sued for anything, at least in Michigan, under $25,000. And most courts have a certain bracket. If you are being sued for this or below, you go to this court. This or below, you go to this court. And that's wherever you go, whether it's venue, jurisdiction, or amount. In federal court, it's more concrete. You can only be in federal court if you have an issue of diversity and it's $75,000 or more. Rarely do you see collection lawsuits $75,000 or more. And it's not usually 2 entities of separate states. That's a requirement under the diversity rule. You have to have separate states, citizens, and $75,000 or more at issue. Or a federal question, meaning you're being sued for a federal statute. That's called a federal question. Or you're being sued, or you're suing somebody for a treaty violation or a federal government question you have. But the lion's share of collection cases are under $75,000, so you're not going to have a federal court issue. The only time you'll have a federal court issue is if you are suing a debt collector, and it's usually, so if you're being sued by Calvary, for example, and they broke the law, you will counterclaim against them in that same state court. But if the debt collector that's suing for them broke the law, maybe they sued you and it's over the statute of limitations, you sue them in federal court under the FDCP. Now, that too is being reduced because you've got to have standing, meaning you've got to show good damages. But my point being is these cases, these collection cases, if you're watching this video right now and you're holding a collection case, see if there's any federal case there. It isn't. The people that suing you aren't citing federal law. We have the amendments to our Constitution, we just go over those, but The 14th Amendment specifically says, here's the state rights, here's the federal rights, and a lot of our problems today, not problems, but issues, are federal government stepping on state rights. In fact, the FDCPA specifically says 1692N, 15 U.S.C. 1692N. If you have a conflict between federal and state law, and the state law grants you greater protections, you stay in state court. If the federal rule or law gives you better protections, you can go into federal court. So, for example, if you're being sued and the process server served you, but he broke a federal law, there's no protections for you against the process server. But under federal law, if you can apply what he did under the FDCPA or any other federal law, you can go get the protections, even though the debt collector is going to go, no, wait a minute, he's operating under state law. That's the 14th Amendment. That decides state rights over federal intrusion. I say all that because today's video is looking at this fellow, George Simmons, and SoloSuit. He is basing his whole information why you should follow his advice under federal law. Debt collection lawsuits, the name of the video is 6 Tips to Answer a Collection Lawsuit. And to answer a collection lawsuit, and he says you have to follow federal law. I'm just simply amazed because federal law doesn't have any ability to stop down at your district court where you're being sued for less than $10,000 or less than $25,000. I have given you plenty of information and videos on one of the most important things in handling collection lawsuits, meaning you're being sued, what do you do to fight back? Remember, an account stated statute is what a lot of these collection lawsuits are based upon. Breach of contract, account stated, and unjust enrichment. The account stated statute allows debt collectors to sue you without the original contract. And we've talked about that. You rarely will see the original contract. So they'll say breach of contract, but they're focusing on the account stated statute, which in Michigan is 600.2145. So if they attach information, including an affidavit saying, there was a deal between the debtor and the plaintiff, they had a contract, now debtor is in breach of contract and is not paying, but he agrees that he had an agreement and he owes money. It's actually stated if the parties expressly agree upon a contract and a sum due, or the party receiving the account does not object within a reasonable time, then there is an account stated win for the collection company. It is what's called a burden shifting statute. So when you're sued for any reason, the person suing you has the burden of proof. It's on them to prove. You can sit there and not do anything and twiddle your thumbs and win a case if they don't meet their burden of proof. 602.145 in Michigan, the account stated statute, is a burden shifting statute. So when they have an affidavit attached under the statute, the burden shifts on you. There's a good reason I'm saying that. And this was codified and created and cemented in a Court of Appeals case called Fisher Sand versus Neil A. Sweeby. I'll just give you the site. 494 Mich. Oh, that's a Supreme Court case. 543. And that is really just solidifying what the trial court said. The trial court said you have to respond, or as we just talked about, you must object to an account stated statute. And in the Fisher Sand case, the debtor lost because they did not object or have proof of why they did not owe the debt with their own account stated affidavit. And the court said it shall be deemed prima facie evidence of such indebtedness unless the defendant with his answer by himself or agent makes an affidavit. And in my last video, I talked about have fun with that. Throw in some stuff and say that they owe you money. I'm starting to use affidavits like that. And unless they answer, now they owe indebtedness. The court in Fisher held that the unanswered plaintiff affidavit under 602.15 created a prima facie case that defendant owed the plaintiff. Why am I telling you that? It's the bedrock of collection defense. They sue you with account stated. Take a look at, if you have a complaint in your hand, you'll see this account is stated. This has become stated between the parties. You've got to have a counter affidavit or you face prima facie case that you lose. Now, when you watch George's video, 6 tips to answer a lawsuit, you'll hear nothing about that. The most critical thing that Michigan requires you do, you hear nothing. That's serious. So if you use a SoloSuit answer and don't bring an affidavit, and I don't see anywhere on their website, and there's tips solidify that you've got to bring a affidavit, a counter affidavit, you automatically lose. Now the issue is, how much do I owe? That's not good if you just paid SoloSuit to do the work for you. So George Simmons advises people in his 6 tips for drafting an answer. We're going to look at some of those. The first bad tip is he's telling people do not answer with any details.
Answer to a debt collection lawsuit. These are awesome 6 tips, so stay with me. Number 1, the answer isn't your place to tell your side of the story in depth and give all the details about your whole life story.
I swear. Now, it is important that you don't tell your story in some parts of litigation. But as I always tell you, you bring that account stated affidavit. David, you tell your story with the court. Why? Because the court just sees deny, deny, admit, admit. It doesn't have a flavor of why you're sitting in front of them. And you may not owe that debt. But if you have presented a counter affidavit and you've told your story, and you've also thrown in parts of the account stated statute that allow you to say, hey, they owe me money. And then the statute can be read, and that's the way I read it, that if they don't have their own counter affidavit to refute yours, now they owe you money. This is important stuff. This is why details are important. This George guy in the SoloSuit says, trust me, lawyers like deny, deny, deny. That's his support.
Number 2, deny, deny, deny. Those are the lawyer's best friends. He's going to want to deny everything.
He's not referring to case law. What he is referring to, in one point, he refers to how you answer a lawsuit is based upon Federal Rule 7. Here's Federal Rule 7. Pleadings allowed, form of motions and other papers. Primary tabs, pleadings. Only those pleadings are allowed, a complaint, an answer to a complaint. That's not telling you anything, and nothing is based upon Rule 7 because you're not in federal court. State cases do not rely on federal court. In the actual video, George says, and I quote, federal law covers the law of the land.
I'm going to be citing the federal rules of civil procedure because those are the rules for the whole nation.
I'm not sure if I quoted that. I have to be honest if I quoted that. But my notes, they'll come up. So not only does George not know the rules that apply to state cases, they're called state courts.
I don't know.
Rules. He says the federal rules of procedure apply to state court because they're the law of the land. I've done this for 30 years. I've never handled a federal collection case. Are there some out there? Yeah, they're usually maybe student loans where you owe gazillions of dollars. That's probably going to be a federal court case. But there's no reference here to the nuances of collection lawsuits, which begin and end in state court. But George says, nope, you have to apply federal court rules. Check it out. What applies in Michigan is MCR 2.11C. That's what governs. Very bad tip number 2 of George is that he says you should deny.
Number 2, deny. Those are the lawyer's best friends. He's going to want to deny everything.
He says no details, and he says, quote, a lawyer's best friend. It is a lawyer's best friend because if you follow this, you will be doing exactly what lawyers do. I'll tell you what happens if you deny. A couple of things. You're going to create a big mess for yourself because the other side can legitimately do the following things. They will file a motion to examine your response, and they'll seek from the court a more definite statement. So now you've just opened yourself to a motion. Now you've got to do the work to defend yourself against a motion for definite statement. Check this out. You just put deny. So you have to go back and answer why you denied. Why? Because the court rules in Michigan say specifically each denial must state the substance of the matters on which you rely upon. So it is fair game for the debt collector to file a motion against you and say, I don't know what they're talking about, because they don't, and you will then have to be in front of a judge, and then you will lose a motion for definite statement. The collection company will then send you a bunch of discovery just to figure out what you're saying, because you just denied. They want to know, and they have a right to know because you broke the Michigan court rules by following George's federal rule assumption. And they will send you requests to admits, and you will get bogged down. They'll then file a motion for summary, and we've talked about this. If you haven't filed your affidavit, which, by the way, your affidavit, your counter affidavit, is your story, and it's going to follow you all the way. If you go to trial, that's your opening statement. You're not seeing a motion for summary or a motion for definite statement. I never see it. I never see this. If I do, it's rare and it's silly. You're always going to see discovery, but why bring this on yourself by not giving details if you truly have a good defense? George says that you should include affirmative defenses in bad tip number 3.
Number 3, include your defenses. Don't forget the defense. A lot of standard templates online or at the court, they don't have the defenses or affirmative defenses. You got to include your defenses.
But he says you should rely only on SoloSuit because there are none out there for you to look at. You can't go online and find template answers or affirmative defenses unlike his. Well, I give them to clients every day. There's a specific website you can go to, a fill-in-the-blank website that doesn't charge you and has affirmative defenses. I'll put it on Shazam. It's up there. I'll put it right up there. This stuff is kind of bad, what he's doing. He later relies upon Rule 8, Federal Rule 8, and gives you and says you should look at the general rules of pleading.
And in this video, I'm going to be getting into the laws. I think it's important for you guys to know how the law actually works and what laws apply to the situation. The laws that govern writing an answer are called the rules of civil procedure. I'm going to be citing the federal rules of civil procedure because those are the rules for the whole nation.
But Federal Rule 8 doesn't apply because it's a state case. It's kind of frustrating. This Mr. Simmons tells you that he will take care of you and then goes on to say that the laws applied to answering the lawsuit are 7 and Rule 8, even though the rules of civil procedure aren't governing state court cases because of the 14th Amendment, because we have our own rules in state court that show us how to answer a lawsuit. But George says, and now I've got the quote, "The federal rules are for the rules of the nation." They are not. You only use the federal rules of procedure as opposed to federal rules or treaties or you only use that stuff when you're in federal court. No state says, "Oops, sorry, you followed the state law, or you should have followed the rules of the nation." You'd have 14th Amendment issues and battles at the border and all this stuff if you believe George. Totally off the wall wrong. And referring, as he does, to Federal Rule 7A2, when it doesn't really mean anything, is just his way of saying, hey, look at me, I know federal law. At 139 to 147 of his lovely advice, the 6 tips, George says you can do 2 things when you answer a complaint. You can admit or deny paragraphs to the complaint, and then you can state your defense.
You admit or deny paragraphs that are in the complaint, and then, second, you state your defense. Those are the only 2 things you do.
These are the only 2 things you do. That's not true. You have to give some detail. The court rules say, and I quote again, each denial must state the substance of the matters. That's the court rules you have to follow. And then when he talks about how you have the option to say, if you don't say admit, you don't say deny, he says you also have the right to deny for lack of knowledge. If anybody knows something about lack of knowledge, after looking at this video, it's George. He actually says, and I swear he says this. In fact, I'll run the quote after this. He actually says, as to how you put lack of knowledge, he says, oh, you know, whatever, I don't know.
Then third, you deny for lack of knowledge if you're like, oh, you know, whatever, I don't know. Deny for lack of knowledge, right?
Lack of knowledge is something George knows a lot about, from what I can see. You're going to get rooked if you follow this guy's advice, in my humble opinion. Been doing this for 30 years. Doesn't make me any better than anybody else, but you do pick up a thing or 2. George, I don't know if he's picked up anything if he's applying federal law. That's at time 2 minutes and 39 seconds of his video. You'll see he just doesn't know what he's talking about. Let's run that, him saying he has no knowledge. Shazam.
Whatever, I don't know.
So he again says you admit or deny paragraphs to the complaint, and then you state your defense. Those are the only 2 things you do. Well, there's a lot more to it, as I said. Back it up. The Supreme Court, in a case, again, Fisher Sands, says you better bring that counter affidavit or you're going to lose. And the rule, the account stated rule says there's a prima facie of evidence when you don't bring a response to the affidavit. The only thing that's at issue is the amount that you now owe the debt collector. And we've talked about summary dispositions. One of the things you're going to face if you follow SoloSuit, that's a mess. You know how I know all that? Because that's where I get clients from. People that go through SoloSuit come to me after they go through SoloSuit. And they go, I just got inundated with all these motions and discovery. And I said, well, how'd you get this far along? He said, well, I use SoloSuit. And there it is. Deny, deny, deny. He actually says in the video, just deny everything, quote, because that's what lawyers do. No lawyer denies everything. The client is represented by an attorney. So anytime an attorney talks for a client, the client is deny, 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 and that's who's going to face the problem. So whether you have an attorney or not, no attorney, I think the guy claims to be an attorney, but he's doing a good job bringing that into a material issue as to whether he is, in my opinion. At 3.07, he says, attorneys always say deny, 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 and again, they don't. This guy is getting people into trouble. They are facing motions for definite statement. This is what's going to happen. Discovery, and then a summary motion based upon not following the most important rule that George says nothing about. That's MCL 600.2145. Look at the Fisher Sand case. Again, 49 Mish 543. That'll explain everything to George. In fact, someone should give that to George. Give this video to George because he needs the help. And again, he claims there's no forms online. You can do it as well as he can. There's free forms online, and I put up the website. I'll put it up again, Shazam. Okay. The biggest blunder, other than telling you that federal rules are the rules of the nation, therefore you only must follow them. The other blunder is his no reference to the counter affidavit. So if you have a you have an affidavit against you in your collection case against you, and you don't counter, you're going to lose if you listen to them. That's my opinion. He then goes on at 6:29 of his video to say, you got to follow Federal Rule 12B. No, you don't.
And those are found in the Federal Rules of Civil Procedure 12B. Okay, these are called 12B defenses.
I do a lot of federal law, by the way. I've got hundreds of federal lawsuits in Florida, in Michigan, Virginia, Texas, California, all over the place. I've done a lot of work in federal court. I can tell you it doesn't apply to state court with good knowledge. You can use federal statutes in state court cases. I do it all the time. But these aren't state court cases where a federal statute is at issue. And again, a statute is not a rule of procedure. A rule of procedure is how you handle the laws or the statutes and how you litigate those things. So he sometimes says the rules are law. They're not. So he's telling you to follow Federal Rule 12b-6. Please don't. Unless you're in federal court. One of the funniest things he does, you got to go check this out. He talks in tip number 5 or 6, he talks about the certificate of service. Now, generally, what he's saying is good. He's saying you've got to let all the parties and the court know when you answer. And that's true. You don't send it, you send it to the attorney that's suing you for the client, their client, and you send it to the court. Now, keep in mind, this is the coolest, funniest thing. Look at, I think it's at 11.
Tip number 5, include the certificate of service. This is covered in Rule 5, interestingly enough, of the Rules of Civil Procedure. It says basically if a party is represented by an attorney, service under this rule may be made on the attorney unless the court orders service on the party. Okay, so if there's an attorney, you just want to serve the attorney.
He quotes the federal rules again. That's totally wrong. Then he shows you his document and how you should follow it for the certificate of service. That's the document showing the court that you notified them, the other side, that you filed an answer, and you're telling the court, which you have to do, the certificate of service. It's a proof of service, but we'll call it certificate of service. And he quotes the Rule 11 of the federal rules. It doesn't apply in these cases. But here's the cool thing. He shows his own document of certificate of service, but he screws up his own document. So he's created a video using his own documents, and the document is wrong, and he realizes it.
How you serve the plaintiff and the court. Most cases it's going to be by U.S. mail. Okay, via mail here. So then it has the address. In this case, we're actually missing the court address. I apologize about that, but yeah.
He says, whoops, I screwed it. I think it's 1139 to 1152. He says, oh, wait a minute. My own document is missing the court address. I apologize for that. But think about it. He created this video that you're watching, and he screwed it up on his own. And not telling the court could cause you problems, especially if you refer to Rule 11, which doesn't apply. Rule 11 from the federal law. Unless it has MCR in front of it, here's a tip. If it has MCR in front of it, Michigan court rules, now you've got a good start. If it has MCL in front of it, Michigan codified laws, now you've got a good start. If it says MCLA, Michigan codified laws annotated. If it has MCLA or MCL or MCR, look for the M. It's a better start than following the federal law that, again, Mr. Simmons says is we have to follow because they're the rules of our nation. Totally blowing the 14th Amendment out of the water. Again, in 1301 of the video, he says you can pretty much deny everything, whatever you want. It's up to the other side to prove that everything is true. I need to quote that again. George states in his video at 1301, you can pretty much deny whatever you want, as it is up to the other side to prove that everything is true.
On the other party, it's up to them to prove that everything's true. You can deny pretty much whatever you want, right? You should be truthful. Like if it's clearly true, you might not want to deny it. But generally speaking, you really just deny everything. That's what most attorneys do.
I'm calling bullshit on that because that is the worst, one of the worst things you can say. If they, you just heard me say this, if they, meaning the debt collector, has an affidavit, what does it mean? It's a burden shifting statute. The burden of proof is dumped on you. So if you listen to George and you pretty much deny everything because it's up to them and they've used an account statute, stated statute, which they do most of the time because they don't have the original contract, you're going to lose under 600.2145. If you listen to George, who says just deny everything, and he says it's what attorneys do and they love. Deny, deny, deny. What attorneys say this? I don't know who he thinks he's talking to, but he shouldn't be talking to Michigan residents like that. So this guy's getting away with this. You know what? Here's two words. Caveat emptor. Buyer beware if you're going to buy this schlock. It's schlock because it's telling you the wrong things according to his own words, George's words. So remember, if you have an account, stated statute, or an affidavit attached to the lawsuit you're facing, and don't just deny everything because the burden of proof is on them. It isn't. It's a burden. I keep saying it because I want you to get it. It's a burden shifting statute, meaning you have to prove everything now. You have to prove that you don't owe the debt. That's why when you don't bring the counter affidavit, the court says that's prima facie evidence of your indebtedness. You didn't, and George doesn't seem to know Michigan law. Why doesn't he know? Because federal laws control our nation. And it's just sick I'm getting sick. I get these cases all day long. So now I have to file a motion to amend the answer. And sometimes I got to beg the other side. Can I just amend the answer, please? Because clearly my guy's going to lose. Then I've got to do a counter, and I've just got to hope that I can save people in time after I get a SoloSuit client. Just remember, a lack of detail hurts you in a debt collector law firm lawsuit because they will file a motion for definite statement. Do you want to face a motion for more definite statement? Do you know what it is? You don't want to have to file a response to any motion. Do you want to answer a bunch of discovery? Then use George's forms. Do you want to be facing a motion for summary with no support to win your case? to show you have a material issue. Remember, we've talked about that. You have to show a material issue of dispute. And you will if you have followed the rules of Michigan, which say have a counter affidavit. So if you follow this guy's instruction, caveat emptor, buyer beware. If you don't use that account stated response affidavit as he's not telling you anything about, you're going to be in trouble, and I can't always get you out of it. I've been around long enough where I can get you out of it, but I don't want you to come to me already in the mess, because you're already in a mess, and now you're doing one of these solo suits. This is all my opinion, but I wanted to be specific about what he's saying and why George is wrong. I'm going to play you exactly what I can't get out of my head. And this is what he says. What do you think about the burden of proof, George? What do you think about the counter affidavit? What do you think about following Michigan rules, please? What do you think about the fact that there are affirmative defense websites you can go to, unlike what you're saying? Hey, what do you think about the 14th Amendment, George? I think George is going to say this. Shazam.
No, whatever. I don't know.
In my opinion, these instructions that you are looking at from George's or SoloSuit's 6 tips to answer a collection lawsuit are going to get you into trouble and probably end up costing you money. Nothing is free, but I wish you the best of luck if you use SoloSuit. In my opinion, again, if you agree with me, I'd appreciate if you subscribe. I'm here sometimes as a policeman. Not just, it's weird because usually I'm yelling at debt collectors doing bad things. This is a guy, by the way, and I must say this. If you stop a default using one of these SoloSuits, that is a little bit good. You don't want to be defaulted. So at least the 21 days are honored and you've got something out there. But I want to show you it's not enough. It's not enough. You're actually hurting yourself if you don't answer properly. And following George's advice in his 6 tips to answer a collection lawsuit is going to cost you money. But I wish you the best of luck if you choose to go that way. Just remember, caveat emptor. Thank you. I hope you subscribe. Give me a comment if you think I'm full of hot air. And but just go look at his video. I'll put the link at the beginning. I put the link at the beginning. I'll put his video link, Shazam, at the end of this as I'm closing out. And I wish you the best of luck if you go through SoloSuit. Contact me if you need help. And I really want to hope for the best for you if you're facing a collection lawsuit. Thank you.